Hi, good afternoon. Today is Thursday, February 16th, 2023. My name is Ashley Glover, and I'm here with attorneys Eric Einhart and Christine Fung. And we are happy to welcome you to our webinar, Decision Making, the Essentials of Guardianship and Advanced Directives. So let's kick off with a few housekeeping notes. This presentation is scheduled for 30 minutes. We have our webcams on and we are sharing the PowerPoint. To help minimize background noises, your mics are muted, so you'll want to use the Q&A box to submit your questions. We've saved time at the end to answer as many as we can. Feel free to chat with us or among yourself using the chat box. Also, we are recording this and we'll email you a link to the recording. And finally, we always value your feedback, so please let us know how we did in the webinar survey, which will appear on your screen once the webinar ends. All right, so now I'd like to introduce today's presenters, Eric Einhart and Christine Fung. We'll start with Eric. He's a dedicated partner at Russo Law Group. Some of his practice areas include elder law, estate planning, guardianship, and trust and estate administration. He's the secretary for the National Academy of Elder Law Attorneys, officer for the Board of Directors of New York NALA, and he's the editor-in-chief of the NALA News. Christine Fung is an associate at Russo Law Group. Her practice areas include guardianship, elder law, and estate planning. Christine has over 10 years of guardianship experience in both the public and private sector. She's eligible to serve as a court evaluator and guardian ad litem, and she's represented the City of New York in hundreds of proceedings as an agency attorney. So thank you both very much for being here. Eric, I believe I'm handing it over to you to cover today's agenda.
Thanks so much, Ashley. I appreciate the warm introduction, and I'm really excited to be here today, and I'm grateful for you all for your time, and I hope you learned some good information. What are we going to cover today? We are going to cover how decisions are made for individuals who need help, financial decision-making for individuals who need help, healthcare decision-making for individuals who need help, and we're going to talk about guardianships. So before we move on, I just want to touch base on the individual who needs help, that part of the question. How are decisions made for an individual who needs help? What we're talking about is the person who lacks capacity. In New York State, all adults are presumed to have legal capacity unless a court determines that they do not have legal capacity. But what we're talking about is someone on a very practical and real level is not able to make decisions for themselves, whether it be financial, healthcare, or personal, either because of traumatic event, chronic illness, or they may never have had the capacity to make decisions on their own. So those are the individuals we're talking about. We always want to make sure that no matter what legal mechanism you're using to help people make decisions in this situation, you always take their input into account. You'll have a legal obligation to do so in many cases, but also you have a moral and I think it's a really appropriate way to approach these kinds of questions. How are decisions made? First and foremost, try to get the input to the largest extent that you possibly can from the individual, and then help them make those decisions. So let's move into how your finances will be taken care of. So if someone lacks capacity and they need your assistance to help them make decisions for themselves, you hopefully will have some help from some prior planning that individual had done. So hopefully the individual had prepared through an attorney what we call advanced directives. That would be a durable power of attorney, a healthcare proxy, HIPAA authorization, and possibly a living will. And if they had done the planning ahead of time and they have a durable power of attorney, you're going to be in a position, if you are the agent of that power of attorney, to help manage their finances and handle their legal needs as well. So not all powers of attorney are created equal. I think that's important to know. So there's a bunch of different types of powers of attorney in New York State. What we advise our clients and suggest that our clients have is a general durable power of attorney. We want it to be a durable power of attorney because we want the power of attorney to be in effect while the principal, the person who creates it, has capacity, and if they lose capacity in the future, it survives, it's durable in the event that they lose capacity. And in New York State, we have a statutory form for the power of attorney. So it's not just something that, someone creates out of thin air or drafts from scratch. There's an actual framework to it included in the statute in New York State. So it has to follow that statutory framework in order for it to be a legally valid, durable power of attorney. So not all powers of attorney are created equal, as I mentioned before. There's powers of attorney that were created years ago that are still legally valid, but they're just not as enhanced, or they don't have the up-to-date powers that they could have if it's done recently. So you want the latest and the greatest durable power of attorney that's drafted by an attorney who knows what they're doing, and will help guide you through the process of preparing it and executing it and implementing it. Hopefully, hopefully it's not needed in the future, but if it is needed, they can help implement it. So you want the latest and the greatest power of attorney. And if you're the principal and you're thinking, well, who's going to help me out here? You are appointing an agent or co-agents to make decisions for you, financial or legal decisions. Now, in a durable power of attorney, you could have one initial agent and then successor agents, or you could have multiple co-agents that serve together. And generally speaking, I suggest 2 is a good amount. If you have more than 2, you're legally entitled to appoint more than 2, but there could be factions that are created. So 2 is generally, in my opinion, the max you should consider, although it's not a legal requirement. So you can have co-agents, and those co-agents could either have to act together, or you could authorize them to act separate. So if you allow them to act separate, then I have a sister and a brother as co-agents for mom or dad. Then brother can make financial decisions on behalf of mom or dad, and sister could help out as well. They don't need to be in the same place at the same time. The agent owes the principal, that's the person who's established the power of attorney, a fiduciary obligation to act only in their direction if the principal is able to give them direction. And if the principal is not able to give them direction because they lack capacity, either mental or physical, then they have to act in their best interest. And it is always in the principal's best interest to make sure their bills are paid. It is not always in the best interest of the principal to go on a trip to Vegas or something like that. So that there is a very clear understanding of a fiduciary obligation that the agent or co-agents have to the principal. The power of attorney can provide all kinds of authorities. You can make it as robust and broad as you like, or you could narrow down the types of powers that you are going to give your agent or co-agents to a scope of powers that you feel comfortable with. So you can kind of cherry pick the powers that you're thinking of giving to them. In my experience, if we're planning for the unknowns of life and the future, my general sense is to recommend to provide the agents with a broad level of authority, because you never know what's going to happen in the future. And if you kind of limit their powers, you may not have given them a power that's going to be very important if you lose capacity in the future. So I generally suggest that you provide your agents with a broad level of authority. And this authority can also include gifting provisions. And these gifting provisions could allow your agents to make gifts of your resources to trusts, to other family members, or if you allow them to do self-dealing, and even to themselves. And the gifting provisions aren't necessarily because you want your agents to be generous with your money. It's really a matter of making sure that, God forbid, you're in a situation where you need your agents to step in and help enact or implement long-term care planning. If, God forbid, you need to qualify for long-term care benefits such as Medicaid that are means-based, these provisions will allow your agents to step into your shoes and enact this kind of planning that's going to help cover the cost of your long-term care should an emergency occur, or should the reason for this type of long-term care benefits be needed. So they can step in and gift assets out of your name into another entity or another person's name in order to help you qualify for government benefits. Or if you are in a situation where you have a taxable estate, they can help do tax planning as well. So gifting provisions doesn't always sound like something you want. Oh, I don't want my agent to give gifts, but it's really for a strategic purpose. And the self-dealing is oftentimes you have an agent who is the natural object of your bounty, right? So I have 3 kids. Other than my spouse, I would name my 3 kids, one of my kid as an agent under my power of attorney. I may want my kid to give money to themselves in order to get it out of my name to help me qualify for a government benefit or help save on taxes. So I don't want them to be prohibited from giving to themselves just because they're the agent. So you may want to provide self-dealing as well. But these are all different authorities or powers that you could speak with your attorney about before authorizing. So a lot of times clients will have questions about things, and before we have them sign anything, we go through and answer all questions and make sure they're comfortable, right? So it's a very important document and a very powerful document. So let's talk a little bit about what you can do with this document. Financial decision making. The agent under your power of attorney can handle management of your assets and your income. That means anything from handling your banking, handling brokerage accounts, buying and selling stocks and bonds in your brokerage accounts, authorizing those trades or that financial management. They can handle your real estate. They can handle digital assets if you're heavy into crypto, or if you have a lot of Amex points or something like that. That would be an example of digital assets. Handle your pensions, your IRAs, 401k plans. They can handle your taxes, both real estate and income, or gift taxes if that's an issue. And they can also step into your shoes in the event that there is legal action that has already been taken or needs to be taken. So for instance, if I get into a car accident and that's the reason why I now lack capacity, my agent under the power of attorney can step in and either pursue litigation against the person who hit me, or if I hit somebody else and they're suing me, they can step into my shoes and help defend me in that lawsuit. So they are kind of your alter ego, depending on the powers that you give them, with regard to your finances and your legal needs. Also, something silly that you don't want to think about oftentimes is picking up your mail from the post office. So you get a little sticky that says, we tried to drop off your mail, come to the post office and pick it up. No one but you can pick that up unless you have an agent or a power of attorney that has the legal authority to step in and pick up that mail. So it really is a broad range of powers that you can grant your agent or your power of attorney. So now that we talked about finances and legal decisions, who has the right to make healthcare decisions? First and foremost, you. And unless you do not have the ability to make the decision, whether you can't communicate it or you can't understand that decision, you will always have the right to make decisions. If you establish and execute a healthcare proxy, you can designate an agent to make those decisions for you, only if you're not able to communicate or understand it. So I've executed my healthcare proxy. My wife is my healthcare proxy. I'm in the doctor's office with her there, and the doctor asks me, do you want this surgery? I say yes. She says no. My decision matters. Hers doesn't until I hear about it when I get home. So healthcare proxy is an important document that will allow you as the principal to select an agent. You can have 2, you can only have, or more than 1. You only have 1 at a time. You can select an agent and successor agents that can act as your surrogate in the event that you lose the ability to understand or communicate your medical decisions. And these surrogates, these agents, are really just stepping into your shoes and making decisions that you would have made if you had the capacity to make those decisions. They are not supposed to be substituting their judgment for your own. So it is very important, if you execute a healthcare proxy, or if you have one right now and you have agents under your healthcare proxy, have a really candid conversation with your agents and your agent and your successor agents about what kinds of medical treatment you feel comfortable with and what kinds of medical treatment you do not feel comfortable with. This way, they're not put in a position where they have to make a judgment call about your healthcare decisions. They can just say, oh, yep, spoke with so-and-so, and they definitely wanted this, or they definitely did not want to have this kind of treatment. And they can make a decision based off of your input, not based off of their best guess of what you would have wanted. I kind of call that the guilt-free conversation, because if you have the conversation, they don't have to have a bunch of guilt about making the wrong decision or the right decision. So healthcare proxy is very important. In addition to naming agents, you could identify your wishes with regard to organ donation, whether you want to, donate any organs, some organs, or no organs. You can identify that on this document. You could also identify your wishes with regard to artificial nutrition and hydration to a certain extent. So who has the right to make life-sustaining treatment decisions? This is your end of life care wishes. You have the right to make your own decisions, provided you have the ability to communicate and understand those decisions. So if you do not want to have a artificial ventilation, hydration, nutrition, life support, essentially, then you make that decision. In the event that you do not have the ability to communicate or understand those decisions, then your healthcare proxy is not going to have that power to just all of a sudden just come in and say, nah, they didn't want to have those artificial interventions. You have to have evidence. And in New York State, not to get all lawyerly on you, but you have to have clear and convincing evidence, which is a really high bar to have. And the best way to make sure that you have the clear and convincing evidence necessary for a healthcare provider to remove or withhold extraordinary life-sustaining treatment, life support, is to have a living will. And this name gets confused constantly with the last will and testament. It is different. It's a very different document. You need to have a living will if you do not want to have life-sustaining treatment in certain situations. So the triggering events of the living will is you have to have a persistent vegetative state. You have to be in a terminal setting, and 2 doctors have to concur that those are the circumstances. You're in a persistent vegetative state, and your diagnosis is terminal. And that's when a living will can be presented to the healthcare provider, and that's when they will honor those wishes. And this living will reflect your beliefs and explain how you feel about pain relief medication, and explain how you want your pain relief medication to be administered. If you do not have a living will, the default in New York State is that the healthcare provider will keep you on extraordinary life-sustaining treatment, such as artificial ventilation, hydration, nutrition, indefinitely until a court order can be granted that would be issued by a judge authorizing the removal or the withholding. And again, you're going to need to provide clear and convincing evidence, which is pretty challenging. So if you are not, if you are the kind of person that does not want extraordinary life-sustaining treatment, my strong suggestion is that you have a living will executed, drafted by an attorney and executed in the presence of an attorney. This way, your wishes are going to be honored, and you don't have to have your family or your loved ones go through a lengthy court proceeding just to have those wishes honored. So, what happens if you do not have advanced directives like power of attorney, healthcare proxy, living will, HIPAA authorization? Well, I have my friend and colleague Christine Fung here is going to help us out. And my understanding is no one has the automatic legal right to make those kinds of decisions, financial or personal or medical decisions for you. Is that right?
That's correct, Eric. Hi, everyone. I have a little bit of a cold, so I apologize if I sound a little bit congested. I might have to take a water break here and there. But to answer Eric's question, what happens when you don't have advanced directives? Well, you will end up coming to see me if you're at Russo Law Group, because I will be talking to you about guardianship. And that happens when there is no planning in place, such as those documents that Eric has mentioned before. And Eric's correct, no one has the automatic right to make decisions for you, personal or financial. That's something that has to be bestowed upon you for that person by the court. So if we go to the different types of, that if we're talking about like making medical decisions, New York State has a Family Healthcare Medical Decision Act, and there's a hierarchy. So if you're looking at this slide here, the top dog here is guardian, and then is spouse, son, parent, brother, close friend. If you want to move up that chain, you can only really do it by applying to be guardian. So, for example, if you have a family member who, if you have like a brother or sister and you're trying to get guardianship for your father, then in order to move up, you'll be kind of seen at the same situated at the same level. But if you want to be guardian, they'll put you up on the top, and you would be able to have the decision-making capabilities for the medical decisions, and that's important here.
So Christine, this is a situation where someone
Awesome.
doesn't have advanced directives. They don't
That
have a
doesn't-
guardianship appointed yet, but they're in a hospital situation. And the question is, how does a healthcare decision get made? Are you saying this is a hierarchy of people who have the authority to make those decisions?
Yes, it's provided in the
Okay.
law, and this is the list that they'll go off of. So in order to,
So if I don't have a spouse and I have like an 18-year-old kid, that kid is going to make those decisions?
correct,
Oh boy, okay.
right,
So
so
that's a lot to bear.
that's a lot to bear, and it's not to be taken lightly, but this is the list that they have to go with. There's no automatic giving powers to somebody outside of this list. So if you took away guardian, the top would be spouse, and then you have the 18-year-old kid, so you don't want that perhaps. And so we move into guardianship, which is in the next slide. So basically, when you don't have those planning documents in place, then you're going to rely on guardianship. And so you're basically asking the court to appoint somebody to have the ability to make those decisions for you. And there are 3 types of guardianship proceedings in New York State. They're all protective. And I want to stress that, because that means that once you put the petition in to get a guardian, the court now kind of assumes the protective role of that individual. So let's say you're going to the guardianship for your father, then it's not just going to be, you be the guardian and that's it. The court now is heavily involved in it. And in order to get a guardian, it is based on clear and convincing evidence. It's a very high standard, because you're basically asking the court to take away the civil rights of that person to make decisions on their own, and instill, decision-making authority on you if you were petitioning for a parent. And so I'm going to use that example here, where it is a parent and their child. So the first one is Article 81. This is what they call a tailored guardianship. And what happens here is it's usually I'll give you more common examples of where 81 applies. It's usually like, for example, for a parent who may have Alzheimer's or dementia. That's pretty common. They had one point had capacity, worked all these years, retired, and now maybe having severe issues with like paying bills, forgetting things, right? Owns a home, has a mortgage, forgets to pay taxes, forgets to pay utilities, and all of a sudden they're getting like that, they're getting like bill collection, and their home is in jeopardy, and but they can live in the home, but they need somebody to help pay the bills, but no one has access to the money because you didn't have the power of attorney to allow you to get access to the bank account for your dad. So what happens here? You need to petition for a guardianship, and the court's gonna evaluate, okay, there is a aspect of Alzheimer's, but they also ask, like, what's the risk? And the risk here would be, I can't pay dad's bills because I don't have access to his money to pay those bills and make sure he's able to live at home safely, right? So that's an example. But Article 81 is a tailored guardianship, so it could be for a financial guardianship, but there are also personal guardianship. So let's say, like, for example, for some reason you had a healthcare proxy. Dad had a procedure a couple years ago before the Alzheimer's set in, and there was actually a valid healthcare proxy, and he filled out. You may not need that. You may just need guardianship of the property. So it's more tailored. The other type of guardianship here, and I don't know if there are people who are watching that may need 17A guardianship, and that's typically, and I'm just giving you a typical scenario of a parent who has a child who has special needs, usually an intellectual disability or developmental disability, and they're going to age out when they hit age 18, which is the magic number of being an adult. And there's always been this, care that you've been giving this child for all their life, and you've been the natural guardian. It's just a continuation of that. But the court now also will also examine whether or not a guardianship is needed based on the child's functional limitations, and if they're high functioning or not functioning. And very quickly, 17 guardianship is for a minor. That's usually for, you need to have guardianship for a minor who may be involved in personal injury matter, and so you would have to use 17A guardianship there. I guess the next slide is how to become a guardian. Basically, you should definitely hire an attorney. The next step would be petition the court, and the court will decide on what types of powers will be given to the individual asking to become guardian. And then once they've been appointed, they can act just as you would an agent when they've been appointed. And next slide. I'm just moving along. I've been noticed that I'm running a little bit out of time. The financial benefits of guardianship are listed here. I'll just highlight some of the important things that you should consider. A lot of times you may have the individual who lose the elderly parent who may need Medicaid, and that will be helpful there. You may have the situation of the 17A child who has a special needs trust, applying for a Social Security, SSI, Medicaid. Those are things that you will need guardianship for. You cannot do that automatically unless you have those advanced directives in place. I guess the next slide personal benefits of guardianship. So these are the things for just making healthcare decisions because you didn't sign the healthcare proxy previously. You can make decisions about living arrangements, arrange for medical and dental for the individual, selling their home, selling their property. And then I guess now we're.
What about moving somebody? Now? So if I have a person who lacks capacity, an adult, and they are living in the home and they can no longer live in the home and they're not in a position to make the decision, can a court authorize the guardian to transfer their residence from a home to like a assisted living facility or a nursing facility?
No, you need court permission to do that. That's why I started from the beginning that once you petition the court, you're seeking the relief of being a guardian. It comes with a responsibility and reporting to the court. You can't just act individually. So it's in a way a little intrusive if you don't have a plan in place ahead of time for guardianship. And I explain that to all the clients who come in. It's a process, it's accountability, it's a commitment. It can cause a lot of stress that wouldn't have been necessary if proper planning in place. But I don't want to dishearten people to say like, if you didn't have it, you have to have guardianship. But the thing is, like, it could be avoided. It could be avoided. I would 100%. I think Eric, your story is best college graduation gift is like advanced directives as a package. So it's something that like everyone should consider and understand.
Whether you're 18 years old or 118 years old, advanced directives are very important, and they can be an incredible lifesaver in an emergency situation or if there's a traumatic event. The idea here is you want to make sure you have a plan, execute the proper legal documents, and if you're not in a position to have this loved one or you yourself cannot execute the documents, that it's not too late. There's things that can be done. You can meet with myself or Christine and we can talk to you about guardianships and how to move forward with it. So there's always a way to move forward, and we are here to help you create a plan and implement your plan as well. I just wanted to take a second to talk about the questions. There was a question here that can a Medicaid application be submitted and approved with signed order to show cause when there is no access to documents, or do one has to wait until a guardian is appointed and they try to access documents? So this sounds like somebody who knows what they're talking about, because they said order to show cause. That's a kind of a trigger to me. So they're saying essentially, if you need a guardianship and someone needs Medicaid also, and a lot of times the need for a guardianship runs simultaneous with the need for the cost of long-term care to be paid for. Classic example that I've seen time and time again through our practice is someone suffers a massive stroke or an aneurysm and now is in an a nursing facility, and they're beyond their Medicare days, and they need Medicaid to come in and help pay for the cost of their care, but no one's there to access their documents to help with a Medicaid application or to access their finances to pay for the long-term care costs. Yes, once an order to show cause is issued, that can be presented to the Department of Social Services, and that'll be proof that they cannot, the individual who's the subject of the guardianship proceeding and who needs Medicaid cannot access their resources, and that can help allow them to be approved for Medicaid on a very kind of a temporary basis. Once a guardian is appointed, the guardian has to either access the money to pay for the long-term care, or do long-term care planning through counsel to help them qualify for Medicaid, this individual. So it is possible, absolutely. But there's a lot of ins and outs for guardianship and for long-term care planning that, you know, we are happy to be a resource to you and to your family. And with that, I don't know that we have any more questions, and I'm running a little bit over time.
I do not see any more questions, Eric, so I'll go ahead. Actually, we just had one more pop through.
Yes, can the healthcare proxy agent also be the power of attorney agent? Yes, sometimes there's really one person in your life that is totally available and an appropriate person to be appointed, and they can be appointed as both. Not always, but that's certainly a possibility.
All right, now I don't see any more questions. So we'll wrap up with what makes Russo Law Group different. Our clients tell us that it's our dedication, accessibility, scope of legal services, and years of experience that give them the peace of mind and confidence when working with us. We will not learn at your expense. We've helped over 17,000 families, and we build a relationship with our clients. We care about you, and we want to be your attorney for life. Our firm has 11 attorneys, and we stand ready, willing, and able to step right in and help. We have 3 convenient office locations. We will make home visits and virtual appointments for you, whatever we need to do. So please give us a call if you do have any questions. On the next slide are a list of services that we provide and all the ways that we can help you and your family. We have a robust website at vjrussolaw.com where we offer terrific information, forms, checklists, resources. So take advantage of it. It's all there for you. In closing, I want to say that we appreciate all of you for joining us. Please leave us your feedback in the post-webinar survey that will appear on your screen momentarily. And in case you missed any portion of today's webinar, we will email you a link to view the recording. Eric and Christine, thank you for a wonderful presentation. And until next time, everybody stay safe and be
Thanks,
well.
everybody.
Thank you so much, Ashley.
Bye.
Bye-bye.